Welcome to this extremely important, supremely important candidate forum for the 5th seat of the Montana Supreme Court. My name is Nancy Leifer, and I am the president of the League of Women Voters of Montana. The League of Women Voters was founded 100 years ago in anticipation of women gaining the right to vote with the 19th Amendment to the U.S. Constitution. The League is nonpartisan, a nonprofit, and in Montana, an all-volunteer organization. We do not endorse candidates or parties. The League encourages informed and active participation in government, works to increase understanding of major public policy issues, and influences public policy through education and advocacy. And so today, as part of our mission, we are carrying that out by offering this candidate forum. Before we go on to the forum, however, I would like to just add one little message here in keeping with our mission. I encourage all of you who are citizens 18 years or older to be sure and vote in the 2020 general election. In Montana, mail and absentee ballots will be sent out on October 9th. So the League encourages everyone to vote early and to return your ballots early. And if by mail, by no later than October 20th, and if you're dropping them off in person, no later than October 26th, to give all of our election officials time to process the ballots for counting on Election Day, November 3rd. So, enough of the commercials. I would like to thank the Montana Public Affairs Network for providing the technology to make this virtual forum possible. Our recording of this forum will be available on the Montana Public Affairs Network website by using the same link that you all used to get here today. Now, I am honored to welcome to this candidate forum Mike Black and Justice Laurie McKinnon, both candidates for the Supreme Court Justice position. And I now turn this over to the moderator and League member, Sally Maison.
Thank you, Nancy. Thank you, Nancy. Courts are different from other branches of government. They're supposed to be accountable to the law and the Constitution, not partisan and special interest pressure. Judges are supposed to uphold the independence of the court, to be fair and impartial. Our goal today is to offer an opportunity for these two judicial candidates for the Montana Supreme Court to give Montana voters a better sense of who they are and why they would serve the people of Montana well as an Associate Justice of the Montana Supreme Court, the position that each is running for. To that end, the League has solicited questions from the public for this forum. We have also gathered questions from two independent and impartial sources, the Brennan Center for Justice and a list of suggested questions prepared by the King County Bar Association for use by the public during judicial campaigns. We will begin the forum with each candidate giving an opening statement limited to 2 minutes each. Both candidates were given one question ahead of time, and they will each have 2 minutes to present their answer to this previewed question. Thereafter, the questions we will be asking from the public and from the two sources mentioned earlier. Each candidate will have 90 seconds to respond to each question and will alternate being the first to answer the question. We will end with each candidate having 2 minutes to give a closing statement. Without further ado, I introduce to you Mike Black and Justice Laurie McKinnon. A coin toss has designated that Mike will introduce himself first. After that, we will alternate responses, and Justice McKinnon will be first to give a closing statement. So.
Well, thank you, Sally. And thank you, Nancy, and the League of Women Voters. Thank you for the opportunity to be here today. I think this is a very important forum, and I appreciate the invitation and the opportunity to talk. My name is Mike Black. I was born in Havre, Montana. My family goes back a century in Montana. My ancestors are railroaders and homesteaders, people who worked with their hands. And I began working at a very early age to learn the lessons of hard work and the virtue of hard work. I did all sorts of odd jobs, sold things door to door like seeds, newspapers, greeting cards, even pumpkins from the garden during Halloween for nickels and dimes out of a little red wagon. I did that because the only way that I could get things, that I wanted, like a new baseball mitt, things like that. I've worked hard my entire career. I graduated with high honors from the University of Montana, and then I graduated from Cornell Law School in New York. I could have pursued a career on Wall Street. That was available to me. But no, I wanted to come back to Montana, and I wanted to do public service. So what is my experience that leads me to this position? I have practiced complex litigation for over 30 years. That means I've worked on some of the most complicated lawsuits in Montana against some of the best lawyers for 30 years. That requires me to understand the facts and to figure out what the law is or what it should be. I've also worked in the Attorney General's office for Attorney Generals of both parties, fighting for free elections in Montana and fighting against dark money. And finally, I worked for Montana Legal Services and hoping and helping some of our poorest people get access to justice. So what do I believe in? I believe in protecting the rights of the people of Montana. I believe in settled law. We protect the rights of Montana, including the access to justice. Settled law includes right to privacy, the right of a woman to choose, the right to public access to public streams. I believe that we should enforce settled law. I believe that we should be committed to Montana, and I'm committed to being in Montana. Thank you.
Justice McKinnon?
Thank you. Is that better?
Yes. Yeah.
So this is a very appropriate forum to hold a judicial candidacy and responses. The League of Women Voters is nonpartisan, and I very much appreciate that. I want to begin first by thanking the citizens of Montana for giving me the privilege and honor of serving as their Montana Supreme Court Justice for the past 8 years, and prior to that, serving as a district judge for 6 years in Ponderay, Toole, Teton, and Glacier counties. It's an honor and privilege because not too often are we able to do something that we love, something that we're good at, and also serve Montana at the same time. I think it's very important to emphasize that I am not a politician. This is not a political race, and I have never contributed to any campaign at all. I believe very strongly that the judiciary should be impartial and that our judges be nonpartisan. On the Supreme Court, I have participated in close to 2,000 cases. I have written nearly 500 majority decisions for the court, another 150 concurring and dissenting opinions. My work I've been tireless in my work and faithfully discharged my oath to the citizens of Montana. Prior to that, as a district judge, I implemented a drug treatment court. I resurrected the CASA program, court-appointed special advocates, and I am committed to judicial education. I'm pursuing my doctorate at the University of Nevada Judicial Studies program. Thank you.
Thank you both. The prepared question that we gave to the candidates is the following. What is your vision for the future of Montana's judicial system? What changes would you advocate and why? And we'll start with Justice McKinnon.
So the most important thing is for the judiciary to remain independent and nonpartisan. I want to see that continue to go forward through experienced judges who know how to make good decisions and respect the separation of powers. We need more treatment courts in Montana. We need better ways to address addiction and substance abuse issues. Access is another important issue. I have been involved in creating a mediation program for low-income parents who need resolution of their parenting disputes by pairing those parents up with attorney volunteers that are trained in mediation. I think that principle of mediating disputes should be expanded into landlord-tenant areas of law, debt collection, debt disputes, and any area where we can have the litigant invest in their outcome. I think that's very important, and those are the tenets to mediation. It's also a case processing issue for the courts. If we can dedicate more judges to the complex civil litigation that Mr. Black participates in, then we have resources available as well to everyday people. I also think we've got to look at equality of the law, equality of justice. In Montana, the prevalent minority are Native Americans. We need to look at how Native Americans are disproportionately sentenced, disproportionately detained, and look at data. And I'm currently involved with another member of the court looking at that data to address what we can do and how to spend resources on those issues regarding equality of justice.
Thank you. Mr. Black.
Thank you. I agree with a lot of what Justice McKinnon said, particularly the part of the judiciary being independent and nonpartisan. That's critical. But I want to address one particular thing that's part of what I believe and part of it's personal. And that is I went to work for Montana Legal Services to make sure that we could provide access to justice for the poor. But it was also personal because part of their role is to protect victims of domestic violence. And I grew up in a household where I had a father who put roof over our head and food on the table, but he was an angry man and often violent. And my mother would pack us up once in a while and take us off to safety for a couple of days, and things would get better for a couple of days. But eventually, things would return to how they were before, and she decided she needed to get a divorce. But she didn't have any money. So she had to squirrel away a few dollars here and there for 2 or 3 years in order to hire a lawyer to get a divorce. And during that time, we were still at risk from violence, particularly if my father had found out what my mother was doing. So at Montana Legal Services, I found out that happens every day in Montana still. And we need to figure out a way to stop that and give those people resources. And I appreciate the mediation programs. I appreciate Justice Beth Baker trying to get more funding for legal services. But what we need to do is incentivize experienced lawyers to help these people, to help them get into mediation, to help them get into court and get the help that they need, because those people are at risk. So one of the ways we can incentivize this is to make sure that people get CLE credits, for example, for helping domestic violence and family law victims, for helping them move on with their life. We should also make lawyers publicly identify their pro bono hours and their reduced fee hours so that we know what people are doing. Nobody should have to do what my family had to go through, because I respect my mother. I wouldn't be here without her influence today.
Thank you both. Here is the first question, and I turn to you, Justice McKinnon,
Thank
first.
you.
Much commentary and research has focused on the deep divisions in our country and the lack of trust in our governing institutions. If you agree problems exist in this area, how would you describe them, and how would you seek to restore trust and help heal these divisions? 90 seconds.
So thank you for that question. Actually, that is a very, I believe very strongly in presenting a message that we need to believe in the strength of our institutions during these challenging times. We have 3 branches of government. We've got to respect the boundaries of each branch, and to have a strong judiciary, we've got to remain nonpartisan and independent. That is a foundational check on the executive and the legislature in terms of enacting unconstitutional laws or laws that violate our constitutional rights. It's so important that we believe in our institutions, particularly now when they are being challenged, in order to have a strong democracy. And an independent judiciary is the foundational stability of our democracy. And we have to be able to make nonpartisan decisions and have integrity and leadership in the highest court of the state in order to maintain those institutions.
Oh, do I answer the same question? I didn't realize that. No, I actually do think that the best way to preserve the integrity of the judiciary and the separation of powers is to follow the law. And one of the things that I am most interested in, and I believe very strongly, is the concept of stare decisis and following precedent. Precedent is the bedrock of our judicial system. People have to understand, what the law is and how they're going to be treated on an ongoing basis. There are all sorts of issues that come up and have come before the court that I believe are settled law, like the right to choice for women under the right of privacy in the Montana Constitution, the right to stream access. There are all sorts of cases where I think the law has already been decided, and we need to continue to apply the law in a consistent way so that we make sure that people understand where they stand. One of the problems that I see in private practice is when the court changes direction, doesn't explain itself very well, and people are left wondering, what is the law? And I am committed, when I get on the Supreme Court, to make sure that we explain decisions clearly. If there are cases that appear to be on point or parties argue are on point, that we address them. And if you're changing direction, to do it very clearly, because I think that's lacking often. I'm not necessarily critical of the court in that respect, but I think we can do a much better job, and I want to.
Okay, thank you. Another question, and we'll start with you, Mike. What do you think is causing the growing prison population? What response should society have to prison overcrowding?
Well, as a judicial candidate, we typically don't take positions on public policy. That's not our job. Our job is to figure out what the law is and enforce it. So to the extent that involves a public policy question, the legislators who are enacted to enact statutes should address that, and perhaps the governor. But the role of the court with respect to those issues is to make sure that the trial courts follow the law, they have legal sentencing, and that rights of people are protected. With respect to overcrowding in prisons, I do think that one of the major problems in Montana is the Native American or Indian population in our prisons. They are much higher than the general population. I grew up on the north side of Havre. I understand what Native communities go through. I understand and know who people like A.J. Long Soldier are and how they suffered in jail, and he actually lost his life. I think that the people of Montana need to know that if I am elected to the Supreme Court and when I'm elected to the Supreme Court, that I will be especially attuned to issues involving our Indian and Native American communities to make sure that they get a fair shake in our justice system.
Justice McKinnon?
So I disagree with Mr. Black. I think that there's a lot of room for improvement with respect to overcrowding and the growing prison population that can come from leadership from the Montana Supreme Court. First of all, in 2017, the legislature enacted a widespread reform with respect to probation, parole, and how sentencings and revocations are to be handled by trial court judges. As sitting on the court currently, I've had to interpret those statutes, apply those statutes with an eye towards the reform effort that's being made to rehabilitate rather than to incarcerate. So I disagree. I think there is a lot that leadership on the court can do. We're also looking at the indigent population of defendants and whether fines and fees should be as high as they are being imposed. And frankly, the Supreme Court has issued several orders with respect to overcrowding in the prison population and COVID, and directed the district judges as to the priorities that they should have in terms of releasing defendants. So I think leadership requires that the Montana Supreme Court address the prison population.
What do you believe are the causes of the high rates of minority incarceration? We'll start with you.
Well, that is what I intend to look at, along with Justice Gustafson and Justice Baker and I are trying to see what the statistics are with respect to court data. And the court as a whole is very interested in that issue. When the Black Lives Matter movement erupted and equality of justice became, it's always been an issue, but the courts across the nation tried to respond. The Washington Supreme Court issued a letter signed by all of its justices saying that they were outraged by what was occurring across the nation. Our court in Montana decided, and primarily through the leadership, well, all of us on the court, that the letter was not appropriate. What we should be doing is looking at data and seeing where the disparities exist so that we can direct our resources to addressing those disparities. I have no doubt that the Native American population is being disproportionately sentenced and detained, but we need to have the data in order to go forward and be effective with the programs. I hope that answered your question.
Sure. I want to go back to the last answer. I don't think that it's fair to suggest that I don't believe that the Supreme Court should lead. When the Supreme Court addresses cases or controversies or addresses statutes passed by the legislature, that is their role. Certainly they're supposed to lead. With respect to statistics, with respect to minority populations in Montana, I think those statistics are known. I mean, 3 to 4 times their rate in the general population, Native Americans or Indians, are incarcerated in Montana. There is implicit bias. A.J. Long Soldier is an example of implicit bias in our system, and we have to work harder to make sure that law enforcement, courts fairly treat minorities in the system. I mean, access to justice is more than just an aspirational thing that we should be saying. We should be ensuring access to justice for everybody. And a lot of times that will start earlier in people's lives. So one way that the court can reach out to these communities that have higher minority populations, that border the reservation or one of the larger cities, and go and talk about how important it is to treat people equally and with dignity, and demonstrate that we show equality and dignity to minorities, especially American Indians, and we can do that as part of the leadership that has been discussed this morning.
Thank you. Thank you. What are your views on whether the court as a whole deals effectively with racial and gender bias? We'll start with you, sir.
Well, I think the court as a whole always can do better. And I think that, again, we as lawyers or as jurists deal with cases or controversies that come before them. And they can send the message from the top as to how important it is to make sure that everybody is treated with dignity and equally, regardless of sex, sexual orientation, race, religion, anything like that. I mean, we have to make sure in the criminal justice system that those biases don't creep in areas such as sentencing or jury selection. With respect to civil cases that come before the court, we need to take claims of discrimination very seriously and review them scrupulously to make sure that we're leading and setting policy from the top, that inequity, whether it's based upon any type of minority status or different status, is addressed. And sometimes that requires us to look inside of ourselves to make sure that we are looking at things appropriately and reaching out to people in the community to make sure that we understand what those issues are. I think the court does a good job, and they try. They're fine people, but there's always room to improve.
So I'm just taking notes here. I think Justice Gray, Chief Justice Gray, was the first woman on the court. Then we had Justice Cotter, Justice Baker, and I'm the fourth woman on the court, and Justice Gustafson is the fifth. It's very important, and if we have 3 women justices, female justices right now. And I think that's a good proportion. I think we need to have a representative population on the court. I think we should have a Native American justice on the court. But the court can't appear as all white males. I think it's very important that we are keenly aware of implicit bias. And I am producing, along with other members of the Appellate Judges Conference of the ABA, I'm on the executive committee, and we are presenting an implicit bias training program in the fall, in about a month. So there's a lot that can be done to improve awareness of implicit bias by judicial education. And I think we start by making sure that the court is representative of the population in Montana.
Next question. Do you believe that all citizens have adequate access to legal help and the legal system? If not, what can be done to provide wider and better access? And we'll start with you, Justice McKinnon.
So I, as a district judge and also as a justice on the Supreme Court, have had so many cases with litigants that have not had counsel. They're very difficult cases because litigants without counsel, they don't know how to navigate their case through the system. They don't know the rules of evidence. And as a judge, you're charged with the obligation of making sure that that trial is conducted in a way that can be reviewed on appeal. And as a justice on the Supreme Court as well, I've had to review just thousands of pro se petitions filed by litigants who don't have counsel. And we do try to interpret those cases and provide some leniency to procedural rules, but they still have to be held to the same standard as any other party that comes into court. But that's where my mediation efforts, I think, are so important, because it allows for the party, the parent, the person getting evicted to mediate, take control of their case and afford a better outcome. But definitely, I don't think all citizens have enough access to the court. And also important with that is that it be a meaningful opportunity to be heard, not just coming in, but that their issues are meaningfully presented.
Thank you. That kind of goes back to my response to the first question. I think the most important thing that we can do is make sure that we have, number one, judicial decision makers that understand the issues. And gender is important. I support diversity on the court, but I think you have to look at the background and where those people come from and what their beliefs are. It's not just gender. We need to figure out a way to get people resources in the form of lawyers, because when somebody comes into court and doesn't understand evidence, that does slow things down. But if we can get experienced lawyers to help them, give them some incentives, that will improve the justice system for everybody. It'll improve it for people going through divorces. Mediation is great. Mediation is hard if you don't understand the law and what the likely outcomes may be. That's why we have to expand incentives to get experienced lawyers involved to help people in those situations. It'll be a lot more efficient. It'll be a lot more effective. I would like to see the legislature fund it more. I don't think it's going to happen. We have to provide those incentives because we need to protect Montana citizens who do not have access to justice because their rights are not going to be protected. We need to protect victims of domestic violence and their families because their rights are not being adequately protected. And that's what I want to strive for when I'm elected to the Supreme Court.
What, in your view, is the appropriate role of the courts in dealing with persons with mental illness?
Well, the court has a lot of roles with respect to dealing with people with mental illness. First of all, there are all sorts of statutory provisions, with respect to how people can be committed to or taken into custody for reasons that are beyond their control. We need to make sure that people who are having problems are afforded due process and make sure that before their rights are taken away, that we take every measure to make sure that they're treated with dignity and equally. Certainly, mental illness can be an issue in civil cases, it can be an issue in criminal cases, but at all times, those folks deserve to be treated with dignity. They deserve to be afforded counsel, either to the extent that they have a right to counsel if they're being accused of something, or they're going to lose their rights, and that's provided by the public defenders, or we need to, again, strengthen the incentives for have private attorneys help those folks out. And I think that there are ways that we can do that. And we need to make sure that their rights are taken care of and that they are protected. And when we do that, we protect the rest of society from whatever issues may arise from the problems that they're confronting.
So the mental health statutes are a very complicated area of the law. The statutes are you have to understand them, you've got to read them. Every time I pick up a mental health commitment, I pull out the title under the mental health statutes and review that statute because it is a process, and the legislature has been very clear about when we can commit somebody. It is not a crime to be mentally ill, and it's so important to understand. And the mental health statutes require a mental disorder, but they also require that the person in some way either be threatening another person or their own health be at issue or in jeopardy. And this is one area of the law, and Justice Carla Gray has authored a lot of opinions as well that I have found very insightful. But I have dissented on a number of cases where the court has affirmed a commitment absent the second part of that equation, which is that person has to be a threat to themselves. We've had difficult cases where they have a mental disorder and they're homeless, and how do you handle those situations? Is being homeless a threat to yourself? So these are issues that I have dealt with on numerous occasions, and I have actually, as a trial judge, had to commit people, some over and over again, for treatment. So it is an area where you want experience on the bench, and you also want experienced attorneys. You don't want to have a pro bono attorney coming in, a volunteer attorney, and handling these types of cases.
What are the issues regarding alternative sentences for nonviolent offenders? Justice McKinnon?
So the court, as a district court judge, first of all, I'll start there. I've sentenced so many defendants, and I think, first of all, you have to be clear with the defendant when you're sentencing them as to the reasons that you're imposing the sentence, so that they have a sense, they don't like the sentence they're going to get, but a sense that they've at least been treated fairly in the process and had the explanations given them prior to the sentence being imposed. We definitely have to pursue alternatives to sentencing, and we do. The district judges are pursuing alternatives to sentences. I think as well it's important for justices on the Supreme Court to educate district judges, to participate in that education process, and to encourage rehabilitation in their sentencing. Now, the judges that impose sentences have to also consider the victim and the offenses, and it's a very difficult role and job to impose a sentence on anybody. It's not a feeling that you look forward to doing, and you realize the impact of that sentence on that person's life.
Certainly, with respect to alternative sentences for nonviolent offenders, there are a couple of different ways that we can address that. One thing is that there's a certain amount of prosecutorial discretion as to how they charge people, and whether deferred sentencing and deferred prosecution is something that the court can urge or suggest to the litigants. But I think that a lot of this is public policy decided by the legislature. With respect to sentencing, the district court judge does have to consider the rights of victims, give them an opportunity to be heard. They do have to consider issues like restitution when restitution is required. But district court judges are required to follow the law and review of their decision as to whether or not those sentences are illegal. So with respect to nonviolent crimes, I think the best way to figure out is for the court to lead once again and work with legislators and suggest ways that we can deal in sentencing with nonviolent crimes to make sure that appropriate punishment is available, but also that the rights of victims are taken care of. I mean, it is a public policy consideration. I think that by treating people with dignity and humanely, we always have to make sure that we have that in mind, and the court can take a role in educating the legislature from the bench as to what they're seeing and how they can address some of these issues, because we do have issues with respect to overcrowding in our facilities.
Thank you, both. What are the issues involved in the debate concerning stream access? And we'll start with you, sir.
Well, at least from my perspective, I think that stream access is settled law in Montana since the Curran decision of 1984. The Montana Constitution and the Public Trust Doctrine provide that navigable streams are open to the public for use up to the high water mark, regardless of who owns the property underneath the stream. That's been the law in Montana for 35 plus years. How it comes up in this case, or in this race, is that I think that it's settled law. I think that stream access is often established by prescriptive easements. I think prescriptive easements, if the facts are shown, the court should be open to prescriptive easements. I think that too often, some of the opinions have come up where prescriptive easements are frowned upon. And I think it came up particularly with respect to the Madison County case involving James Cox Kennedy, who was a dark money donor in the 2012 election. I don't know exactly how that all shook out. I think that his organization supported, my opponent in that election. I think it's important for us to follow settled law to ensure that stream access is protected in Montana, and that if the facts demonstrate that a prescriptive easement is justified, that the court should follow settled law in that respect.
Yes, without question, stream access law has been in place since 1984, and I, of course, would enforce any issue respecting that, but I can't say how I'm going to rule in cases coming up. Each case depends on the facts and the arguments raised in the trial court and the issues presented. So, and there's always two sides to everything. But to the extent that there is a statute in place, I would certainly enforce that statute. The case that Mr. Black refers to did involve prescriptive easement law. The area of law, that particular area of law, is well settled. And actually, the case that he refers to has not been cited, and I dissented in that case because I felt that prescriptive law was clear and that the result that the majority was reaching was incorrect. It was a straight-up application of the precedent that we already have. And that issue that was forefront in that case has not been cited. It's an aberrant decision. So when Mr. Black says how it all shook out, I'm not quite sure what he means. I based my decision on the law, and I was not the only dissenting justice in that decision.
Next question. Do you support the federal Equal Rights Amendment? We'll start with you.
Yes.
Do you want to say any more about that?
No.
Okay.
Yes and no, I have nothing further to say.
Okay, moving right along. How would you define...
Wait, could I say something? I think that's particularly appropriate given the anniversary of our women's suffrage. So.
You'll get no argument from me about that. Mr. Black, how would you define a fair and impartial judge, and how would you work to ensure your own impartiality?
Well, a fair and impartial judge, first of all, is somebody who has an open mind and doesn't bring any biases or preconceived notions to either the law or the facts that are before them. I think that a fair and impartial judge has to recognize that all persons before the court should be afforded equally and treated with dignity. And if you start with an open mind with respect to the facts, an open mind with respect to the law, so that you can apply the law as it appears by a plain meaning or reading or by implication from prior cases, then you can ensure that everybody has access to justice. So fairness and impartiality means no personal bias, no personal beliefs, no partisan or political inclination towards one side or the other. And I think that that's something that I'm committed to and always have been.
Okay.
So I began by saying I was not a political person and I have not contributed to any campaign. And I challenged the voters or asked the voters to look at the history of both of us in terms of contributions and partisan activity. I feel absolutely that a justice should be nonpartisan, both on the bench and off the bench. And not only that, we must avoid even an appearance of impropriety, because it's only through the faith in our judgments and our decisions that they are enforced. We don't have an army that we can send out. We don't have the National Guard. They have to be respected and accepted by the citizens of Montana. I think that, it's important as well that judges off the bench not participate in partisan events, partisan activities, and I'm very selective about any forum that I attend for judicial education. It has to be neutral. That's why I've stayed with the ABA and the National Judicial College, because there's a lot of groups that want to influence judges and provide a forum where they can promote their views. So I think it's so important that we practice nonpartisan lifestyles off the bench, and that we're nonpartisan on the bench as well.
This is a combination question. In the state of Montana, if an issue concerning a woman's right to choose her own very personal medical treatment concerning pregnancy arose, would you vote to uphold the law of the land, Roe v. Wade? And what are the major issues involved in the debate regarding abortion? We'll start with you, Justice McKinnon.
So, to begin, I cannot comment on how I will rule in a future case. I will follow the precedent. My precedent is not only the Montana Supreme Court, but the Supreme Court precedent from the United States. But the Code of Judicial Conduct prevents me from saying how I would rule on a case. Now, there have been decisions, and Mr. Black has used those decisions to say that I do not support a woman's right to choose. The decision Reams is a procedural case, and it was on a preliminary injunction whether it should issue with respect to nurse practitioners giving abortions. And the medical board did not authorize nurse practitioners to give an abortion. So the issue, in my opinion, was moot, and the court has to practice restraint in dealing with those cases. And to characterize, I just am not going to say how I would rule in any case that could potentially come before us.
Okay.
I think your question raises two different issues. One is Roe versus Wade, and one is Montana law. Montana law was established in the Armstrong versus State case in 1999, which unequivocally stated that a woman's right to choose was based upon the right of privacy founded in the Montana Constitution. It has nothing to do with Roe versus Wade. I think that everybody interested in this issue is concerned with the death of Ruth Bader Ginsburg and where the U.S. Supreme Court is going to go. But I think the Armstrong case makes it very clear, and it's settled law in Montana, that the right to choose and terminate your pregnancy through a lawful medical procedure is established firmly under the right of privacy in the Montana Constitution. There is no right of privacy in the U.S. Constitution that's expressly spelled out. I don't think the rules of judicial conduct preclude us from discussing issues of settled law. The Weems case was not a procedural case in the sense that is suggested here. The Weems case involved a preliminary injunction, and the majority of the court specifically found that irreparable harm would have occurred if the right to privacy were thwarted and the woman seeking care was prevented from using a lawful procedure for her own personal reasons for her medical care. It was a substantive decision, and dissenting from that opinion leads us to have a reasonable question as to whether or not you support the right to choose.
In the area of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity? We'll start with you.
Well, I've actually litigated a fair number of First Amendment issues, and with respect to hate speech, really the only thing that you are protected from is, if you can remain anonymous if your personal safety is at issue. I mean, unfortunately, people say a lot of nasty things, and unfortunately, the law protects their right to do it. It does not protect your right to threaten people. It's often a concern in domestic violence cases as to whether you are subject to a reasonable anticipation of harm. That can be restrained in those types of circumstances. Hate speech, in and of itself, I think it can be a form of discrimination under the civil laws as well. It just depends upon how it comes up. But in the political arena, let's say in political campaigns, that's where your speech has the greatest protection. And there are numerous cases from a number of courts, protecting your right to free expression. And the remedy to that is more speech. And that's not always the most efficient way to do it, but that's the society we live in because the right to freedom of expression is so important.
Okay.
So just to back up a little bit, I was not the only dissenting justice in the Weems case. Justices Shea and Rice also dissented. With respect to the free speech versus hate speech, I have very little tolerance for hate speech personally, but that's not what this is about. The question will always come down to balancing the constitutional right of free speech versus whether it has gone too far. And that's going to depend on an examination of the facts, the law that's at play, the arguments of counsel, and it really would be a very difficult area of law, as First Amendment the area of law is. But as I said, I think it comes down to looking at the facts and the law in that particular case.
Okay. We need to begin to.
This is the one you're asking now.
Okay. Please describe one instance in which you faced an ethical dilemma and how you resolved it.
Well, I guess with respect to ethical dilemma, the first thing that comes to mind is whether I should recuse myself in a case, but I'm trying to think of a better example. But I have had to recuse myself in cases. My son-in-law is a member of a law firm in Missoula, the Garlington law firm, and there's a statute that would require me to disqualify myself in those cases. So I think that when you speak of an ethical issue for a judge, that's what first comes to mind. I'm not sure. There are definitely numerous cases where I have had difficulty making a decision. But I get paid to make decisions, so I go ahead and make them. But where we don't get decisions or cases in the Supreme Court usually where there aren't two sides to at least every question. So, and I think the ethical issue comes into play when you're talking about how to put aside your personal preferences or beliefs. For instance, with the domestic abuse, a lot of times you see partner family member assaults coming in where they've had prior partner family member assaults. And I understand that cycle of violence and the relevance of those prior partner family member assaults. I see the stop sign is up.
Okay.
Well, I presently sit on the commission. Sorry. I presently sit on the Commission of Practice in Montana, where we judge lawyers who have ethical concerns raised about them. So I look at it every day, but I think that the best example I can come up with as far as my personal situation is I had a case several years ago where I was faced with a conflict between two clients and I was required to withdraw. We didn't have a conflict early on, but I had raised the issue with my client saying that it might come up, and if it did come up, I would have to recuse myself. And ultimately it did, but the problem is that I became aware of facts that I was concerned that some people involved in that case may use them to commit a fraud on the court. It was actually a backdated document. So when I withdrew from the case and quit working on it, I made sure that I documented to the other attorneys involved that this was a backdated document. And it became important because several years later, somebody submitted that backdated document attached to an affidavit in court and stated that essentially it was signed as of the day of the date. And the attorney who submitted that, I had to testify before the Commission on Practice, and that attorney was disbarred. But I dealt with that issue by getting rid of the conflict, withdrawing from the case, and preserving the record so if an issue came up, it could be addressed, and it was.
Okay, and now that's all the time we have for the questions. However, There is a question about a promise to move to North Carolina by Justice McKinnon. And Mr. Black, would you care to address that first?
Sure. I think that there are two aspects to this issue. First of all, I decided to run for this position because it was an open seat. Justice McKinnon had represented to the press that she was leaving Montana for North Carolina. Several months later, she changed her mind after going to Washington, D.C. and indicating that somebody had poured some little bit of cement down her spine and she wanted to run. I don't know who those people are. I don't think they've ever been publicly identified. The Montana Constitution requires that you live in Montana to serve on the Montana Supreme Court. It requires that you live in Montana for at least 2 years consecutively before running for the Supreme Court. Now, I had a few questions, and so as any good lawyer would do, I did a little bit of investigation. I knocked over a couple of rocks, and within about an hour or two, I found a contract recorded in the public record in North Carolina in which Justice McKinnon got a mortgage on a 33-acre horse property for $450,000, where she promised it would be her personal residence for at least a year within 60 days of signing that document. And that was in June of 2019. So I think it's a fair question to raise for the people of Montana as to whether or not my opponent is committed to staying in Montana, especially by virtue of the fact of this contract with the promises that's in the public record. That's easy to find.
Okay. Justice McKinnon?
So, you know, I don't know quite what to say to that because I have served a 6-year term as a district judge and an 8-year term as a Supreme Court justice. We raised our family, 4 children in Montana. All of our children still reside in Montana. My commitment should not be challenged when I file for candidacy and say that I'm going to run for 8 years. We've had 2 homes so that I could do my job as a Supreme Court justice. I missed basketball games to be down in Helena that my boys were playing, and I took the bench with 4 children still at home and then 2 children still at home while on the Supreme Court. My husband was in North Carolina on temporary work. We've always had a vacation home in North Carolina since 2013. We have family out there. To bring up and investigate the way he has done is almost, it's just not a relevant consideration, especially when I've said I was going to run. I've changed my mind. I changed my mind several months before the opening of the filing period. And Mr. Black doesn't have any ownership on his job because I've changed my mind.
Okay. Thank you both. And thank you so much for all of this. We will now have 2-minute closing statements, first by Justice McKinnon, then by Mr. Black.
So I think what I want to first of all say is my judicial philosophy, and I feel very strongly about it. It's what motivated me to go to law school. It's what motivated me to work as a county attorney, and a public servant for 6 years as a district judge and another 8 on the Supreme Court. I believe so strongly that, especially in these times, that our institutions have to be strong. And the judicial branch, in order to be strong, needs to be nonpartisan. And when you've made close to 2,000 decisions on the court, nearly 500 as a majority writer, another 150 as a concurring and dissenting justice, that shows that you have the experience, you've been there, and you can make the institution, protect the institution, the independence of the judiciary. The executive and the legislature are by their very nature partisan. That's where the policy and direction of the state have to take place. However, it's the judiciary that provides the foundational stability that our democracy needs. And without that foundational stability, our institutions will fail. So particularly with the challenges that we face today, it's crucial that we have a nonpartisan judge on the Montana Supreme Court. My decisions have demonstrated that I can be fair and impartial and above all nonpartisan. I also think that the court needs to look at promoting access to justice, improving court services, and examining the law to make sure that law is not only fair and impartial, but that it's equally provided. Thank you.
Mr. Black?
First of all, I'd like to thank the League of Women Voters for inviting us here today. I appreciate this opportunity. I think that Justice McKinnon mentioned earlier the whole issue of the appearance of impropriety. And if you'll notice, when the question of this contract in North Carolina was raised, it was not addressed. This deed of trust in this contract is not for the purchase of a vacation home. If you were purchasing a vacation home, you'd get a different one. You don't have to promise the bank that you're going to live there as your primary residence every day. And that's what happened. I don't know what Justice McKinnon did or didn't do. All I know is that a promise is a promise, a contract is a contract. So let's talk about the issues here. Justice McKinnon has talked about partisanship, implying that for some reason I am not a nonpartisan person. I have never run for partisan office. I have no interest in running for partisan office. This is not a partisan office, and I will submit to you that we should never let partisan politics get involved. I worked for the attorney generals of both parties. One hired me, the other one promoted me. I have always kept politics out of my work. Do I have some personal beliefs? Sure. I think every informed citizen should have personal beliefs. Have I made contributions to political campaigns? Sure, I've done some. I've given to conservatives, I've given to progressives. Mostly, at least with respect to candidates in the state of Montana, they're people I know personally. I give more money to the University of Montana by far for their scholarship funds and to support their programs than I've ever given to candidates. Does that make me partisan because I'm giving to one unit of the university system? I give money to Montana Legal Services to help them, help the poor. Does that make me partisan? No. No, I believe in access to justice. I believe in empowering women. It's interesting. The Judicial Nomination Commission, thank you. I appreciate the time today.
Thank you all. Thank both of you for putting on a wonderful forum, and particularly with respect to the presidential debate. This was lovely.
Thank you.
So on behalf of the League of Women Voters, I thank both Justice Laurie McKinnon and Mike Black for participating today, the Montana Public Affairs Network for providing the technology to make this virtual forum possible, and all of you who attended. A recording of this forum will be available shortly on the website of the Montana Public Affairs Network and can be accessed using the same link used for this live stream. The link is also on the Montana League of Women Voters website. Thank you again, both of you, for participating. I appreciate it.
Thank you for inviting us.
This concludes the forum.
you.